Hello, everybody. Jeremy Ravinsky here, and it's time for another NPC legal analysis of the news. Today is Monday, the 7th of March. As you see on your screen, we all know that Donald Trump has been in the spotlights recently. Last week, a very passionate debate. Before that, there was Super Tuesday just about a week ago now, and he's picking up more and more delegates. But what was brought out, especially recently, was this Trump University thing. What happened with Trump University? Well, as you see on your screen, an article from last week. Even though Trump won big on Super Tuesday, he lost big in terms of a legal battle, right? Trump suffered a legal setback that could explode in his face later in the election year. So, what happened to Donald Trump? Well, Trump formed what he called Trump University back in 2005. He later changed the name because New York State got upset that they claimed it wasn't really a university, but he was uh, having students pay to go to seminars and classes. And he said, I'm rich and I know a lot about money and I know a lot about business, and I'm going to make you rich and you're going to learn a lot about money, a lot about business. He claimed that he was handpicking the best in the field to be professors and to teach. And people signed up. A lot of people signed up, and a lot of people paid a lot of money in the course of about 10 years to attend Trump University. Well, what happened with Trump University? As Marco Rubio brought out in the debate on February 25th, and then again in the debate last week, there are lawsuits against Trump University that is now defunct. It's not in existence anymore. And last Tuesday, the New York Supreme Court Appellate Division said that the case could go on, that the allegations were good to go. They were subject to a 6-year statute of limitations and not a 3-year statute of limitations, meaning that they filed the case in the appropriate window of time for the case to keep going, to go in front of the court. How did we get to where we got to? Well, this screenshot, with the exception of that little asterisk on the bottom that I put there that I'll get to in a minute, this comes from an official press release from the New York State Attorney General. And this was back in 2013. The Attorney General filed a lawsuit in the New York Supreme Court in Manhattan, claiming that Trump University was a bait and switch, a fraud case, and he was taking money by falsely claiming that he handpicked his experts to teach get rich trick tactics, and students were billed out of a lot of money. Keep in mind that he filed this, as I said, as you see on the bottom of your screen, in New York Supreme Court. We'll see if there is legal analysis, legal precedent that will help or hurt the case depending on where he files it. Last week he was on CNN. This is from March 4th. And he said the fraud case is pretty straightforward, right? This was after Megyn Kelly also questioned Donald Trump during the last debate. He said it's a classic bait and switch that Trump said that he was going to teach and he was going to pick the people who were going to teach. And in fact, that's not what happened. He's claiming in the lawsuit that he's filing on behalf of the people of the state of New York that Donald Trump, in fact, had no idea what was going on with the university, or very little idea, very little connection to it. He just kind of put his name on it and was not involved in the day-to-day. There's a lot more with the lawsuit. Basically, as you see from this news site, he said that more than 5,000 people paid Trump University collectively $40 million. And a lot of that money went straight to Donald Trump. And he basically said he put his name on there, but didn't really follow through with it. Now, obviously, we are looking at a legal analysis of the news. This is not a politics debate that we are engaging in right now. This is not, I'm not talking about the merits of the lawsuits that are filed. What we want to do is, I want to pose a question to you, which is, if Donald Trump actually pulls it off, if he becomes president, what's going to be with this lawsuit? Since on Tuesday they said they can continue with the lawsuit, the court said it may continue. if he's president, is he going to be able to say, well, listen, I have a certain presidential immunity. I have to take care of this country. I promised my voters I would make America great again. Um, will this impact the status of the case? That's what I want to present to you today and look at some case law and things like that. So we see here after the attorney general brought this action, as is common, usually it starts off in the public sector, then private sector class action lawsuits quickly followed. And you see here, here's one example. There are actually three lawsuits right now. Here's one example of a class action lawsuit filed in U.S. District Court. So this is in a different court. It's in Southern California, so it's not New York, and it's also a federal court, not a state court. And it alleges that Trump University made materially misleading statements in its advertising and real estate seminars in violation of both federal and state law. So they're asking for a lot of money. They've got a lot of people on board here claiming that they were kind of gypped out of these things. They said that they were signing up for a one-year apprenticeship, but it was actually just kind of like a weekend seminar. And they said they would get mentors, and they didn't get mentors, etc., etc. Again, we're not looking at whether these statements are true or false. We're just looking at this is the reality. They filed this lawsuit, and Trump now has to defend himself against this lawsuit. Here is a page of the actual lawsuit. This is how lawsuits look, right? For those of you who have either filed lawsuits, gotten lawsuits filed against you, or have spent time in school learning about how to file lawsuits. So you see here, basically, this is the nature of the action that they claimed. Trump claimed it was a university, and the claim says it is anything but. The plaintiff and class members claim that they were investing money because they were promised a complete real estate education, as well as an apprenticeship lasting a year, as well as mentorship, and a power team of people surrounding them that would help them. But they said they did not receive what they bargained for. So the question becomes now, what happens if Trump actually becomes president? It didn't look likely when he jumped into the race. People didn't take him seriously. The media didn't take him seriously. Even Jeb Bush and Marco Rubio and the people running against him didn't take him seriously. But after New Hampshire, he claimed a serious victory. He looked like he actually had a chance, right? Then even the Huffington Post started writing articles about how it could really happen. He could actually win this thing. Even the presidency, Bill Richardson, who spent time in President Clinton's administration, ran for president himself as a Democrat a number of years ago. He was the governor of New Hampshire. He came out late last week, just a few days ago, and said that he has a real chance even to beat Hillary Clinton. Right? Trump claimed in the recent polls that he could beat Hillary Clinton, that polls showed he could beat Hillary Clinton. So the question remains, what happens if he could actually become president? And this lawsuit is still finding its way in the courts. Would he be able to just say, no, I need to just spend time in my new chambers over here doing presidential things? What can he say? What would the court say? What's the precedent for this? This is what I'd like us to look at for the next few minutes. There have been only 4 sitting presidents who have been defendants in civil litigation involving their actions prior to taking office. The first president was President Teddy Roosevelt. And there was a case from 1904, as you see on your screen, Hurley v. Roosevelt. And Roosevelt was sued in his capacity as chairman of the New York City Police Department. He held this position previously before becoming president. And he was sued before becoming president. And the case went up to the Court of Appeals in New York while he was president. And the Court of Appeals affirmed the decision of the lower court. The Court of Appeals didn't even really write an opinion in this case. It just kind of outright affirmed the decision of the lower court that dismissed the complaint 9 months before he had become president. The next president that kind of found himself in a similar situation was President Truman. There was a case, DeVault versus Truman, in 1946, where in 1931, again before Truman became president, he was a judge in Jackson County, Missouri. And the plaintiff alleged that in 1931, he and his other fellow judges, his colleagues, improperly committed the plaintiff to a mental institution. It's quite an interesting case to read. So he sued all the judges, including Judge Truman. And the trial court granted Truman's motion to dismiss. And then in 1945, a few months later, Truman became president. This case still was kind of going up in the appellate courts, and the Supreme Court of Missouri ended up taking the case when Truman was president and affirmed the dismissal of the lower court. So again, the president didn't have to defend himself, because in both cases that we saw so far, the case was thrown out in the trial court, and then once the president became president, it was just thrown out on appeal. It was the decision of the trial court was affirmed on appeal. Next, we get into the 60s, and we have President Kennedy. And in Bailey v. Kennedy, the issue was that that President Kennedy claimed that because he was the commander-in-chief, he shouldn't have to deal with a lawsuit. So similar to kind of what might happen as we are projecting if Trump actually wins and the lawsuit continues. However, the court didn't really write an opinion here either. Kennedy didn't raise the issue per se of presidential immunity, and the case was actually decided out of court. It was settled. So again, this doesn't give us much to work with. The best case that we have to look at as precedent is Clinton v. Jones from 1997. In Clinton v. Jones, everybody knows, right? This was, I would say, current events, but now has become history quickly, as 1997 it feels very like a short term away and like it happened a long time ago. In Clinton v. Jones, Jones claimed that Clinton sexually harassed her, and she suffered as a result of this in her hostile work environment, and this was when Clinton was not president but governor, and the case kind of became big and went up to the Supreme Court after Clinton became president. And President Clinton argued that, listen, I'm the president of the United States. I don't have time for defending myself in these lawsuits. What am I supposed to do? You want me to be president and do my job? Or do you want me to spend my entire life, my entire term here in court defending myself against a lawsuit that I claim has no merit anyway? So he claimed presidential immunity. And it's interesting because it was actually a unanimous opinion that was authored by Justice Stevens. And in it, the court ruled that the separation of powers does not mandate that federal courts delay all private civil lawsuits against presidents until the end of presidents' terms. So you see on your screen some excerpts that I thought was some of the key language from Clinton v. Jones. The principal rationale for affording certain public servants immunity from suits for monetary damages arising out of their official acts, the court says, is inapplicable to unofficial conduct. What does this mean? It means that definitely nobody argues that if a president makes a decision, let's say to bomb a foreign country, and somebody dies in that bombing, that person can't then sue the president and say, in your official capacity as commander-in-chief, you decided to bomb this embassy and my spouse or son or whatever ended up being in that embassy. I'm suing you for damages. That is off the table. There's no discussion about that because, as the court says, we don't want a president to be walking on eggshells for 4 years worried about making tough decisions because of potential lawsuits involving those decisions. However, the reasoning in terms of public decisions, the court says, does not apply to unofficial conduct. So if the president did something either while he was in office or before he was in office, as was the case in Clinton v. Jones, that has an effect, a ripple effect on somebody's life, and now they want to sue. Now that the president has become president, then the court says we are not saying that that immunity will extend beyond the scope of an official presidential action. And therefore, the court said that the president could be sued and could have to defend himself at the same time as actually being president because, again, his conduct had nothing to do with his actual presidential abilities or decisions. It was private conduct. And so the court then said that the president is subject to judicial process in appropriate circumstances. And it brought some proof from history beyond what I just explained about the previous presidents who found themselves in similar circumstances. The court said that the first Chief Justice that we learn about in constitutional law, right? Chief Justice Marshall, the famous Chief Justice who wrote the opinion in Marbury v. Madison, Chief Justice Marshall, when presiding over a treason trial of Aaron Burr, he ruled that the president could be subject to a subpoena. So even though he was the president, even though he's a busy guy, the court could still pull him into court and make him answer questions. Likewise, much later on, when President Nixon found himself in a pickle after the Watergate scandal broke, the court likewise said he was obligated to comply with the subpoena that commanded him to produce certain tape recordings. And he said that the court said, nothing you're throwing at us, President Nixon. You want to argue separation of powers protects you. You want to argue confidentiality protects you. You want to argue presidential privilege protects you. None of those things actually shield you of immunity from judicial process under the circumstances, because this was private conduct and the president could be at the disposal of the court, had to answer the subpoenas, had to deal with the court, and the court would not push this stuff off until after the president was out of office. So in conclusion, the Clinton v. Jones decision said that the federal district court had jurisdiction to decide the case. And I think this was very key language here. Like every other citizen who properly invokes that jurisdiction, the respondent has a right to an orderly disposition of her claims. In other words, it wouldn't be fair that if President Clinton's going to be in office for the next 4 years, or even the next year, that we're going to push off the case. It wouldn't be fair. This is private conduct. It affected a private citizen. That citizen is claiming that there was injury to her and she wants redress from the court. It wouldn't be fair to her to push off the court hearing until later. So it seems from this that if we have President Trump, let's say, if Trump's actually able to pull it off and become president, and this lawsuit doesn't go away, and you have all these people coming after him saying Trump University was a fraud. All I got for my $30,000, $35,000 was this lousy T-shirt or this hat or whatever it was. It seems that the president, if President Trump would not be able to get up and say, I'm too busy to deal with this. I'm the president. I have to go, bomb countries, make America great again, whatever I have to do. I have to fix the economy. I can't come into court. That would not be acceptable. There is, however, one caveat. There is some language at the beginning of Clinton v. Jones, which basically says that everything that they're talking about in the decision is limited to federal cases. That we're talking about federal cases here, trying to pull the president into court to explain or justify his private behavior. But we know from constitutional law that we live in a system of federalism where we have two governments. We have the federal government and the state government, and they're separate spheres of government. And so the court here, in classic, one of the principles that we learn about, right, that the Supreme Court will always limit its decision as much as possible and not decide on things that they don't have to decide on. So they said in Clinton v. Jones that it's not necessary for that court in 1997 to consider or decide whether such a claim might have succeeded in a state court, because that wasn't at issue here. And the court acknowledges that there is a concept of federalism and there are concerns there that perhaps it would be more appropriate to adjudicate this in a state court or to not adjudicate it in a state court. Perhaps the court entertains the idea without being decisive that even though President Clinton here cannot get out of this case or cannot push this case off until he leaves the Oval Office, perhaps he would have a stronger hand in doing so if it was a state court that was deciding if he violated state law, if he hurt somebody that was bringing a lawsuit against him. So the court says here, whether those concerns would present a more compelling case for immunity is a question that is not before us. So that's up in the air, and if this would go, as we said before, there is a federal lawsuit, there are actually 3 class action lawsuits, and there's a state action that was filed in New York by the New York Attorney General. So if we end up with a Trump White House it would be a stretch of the law to also say that Trump has to appear in New York court at the time. But it's also possible that even if he ends up in the White House, he still would have to end up in the courtroom. For NPC Legal Analysis of the News, this is Jeremy Ravinsky.